today I want to dip our toes into the vast body of law that is forfeiture and contrast it with restitution. Hello again, this is Lana Manitta with Rawson Law Firm, and I'm here to talk to you today about restitution versus forfeiture in federal criminal cases. Remember to like and comment on this video and subscribe to our channel where we provide a variety of educational videos on criminal defense topics. So today I want to dip our toes into the vast body of law that is forfeiture and contrast it with restitution, because this is something that takes many federal defendants by surprise and is often misunderstood because it seems, well, unfair. It's a complex area of law, and when you're facing an indictment that includes a forfeiture count in a case where there is a victim, including the United States, you may face this issue of what might be considered double dipping into your pocket as a consequence of your conviction that many people do not anticipate, including, unfortunately, many defense attorneys. This issue of restitution and forfeiture is often a matter that's kind of glossed over by counsel who are more concerned, understandably, with the prison time that a client might be facing. But it's obviously and actually a very important piece of the sort of pie of punishment that a client will receive. And it's negotiable, it's subject to challenge, and it's really crucial to understand the two pieces. So in a nutshell, here's the difference. Restitution is in many cases mandated by statute, and the objective is to make a victim whole. Whether this is a victim who suffers a physical injury, the family of a murder victim, the victim of a fraud scheme, the restitution is to reimburse them for economic losses attributable to the defendant's criminal act. And sometimes the economic losses can be sort of injuries that are monetized, but that's a whole other issue. Forfeiture is the government's right to seize and keep assets that are the proceeds or instrumentalities of an offense. And that money goes to the government coffers. Proceeds are money that is made from the criminal act. Instrumentalities could be vehicles, phones, firearms, even real property used during and in relation to the commission of the offense. So in the fraud example, if you're convicted of a fraud where you bilked investors out of $5 million, then the restitution order could be for $5 million to be allocated to each victim according to their share of the loss. But the government can also seek a forfeiture of $5 million as the proceeds of the crime. But wait. If you spent all the money, how are you going to pay $5 million, let alone $10 million? Well, the government can go after, on the forfeiture side, substitute property. Now, there's certain, but unfortunately broad circumstances under which they can go after your house, your car, etc., if the original proceeds or instrumentalities are no longer available. So you must be thinking, okay, well, if the government takes what they get for forfeiture, they'll give it to the victims and my restitution will be covered. No, they don't have to do that. They may not do that. And this is something that really can and should be addressed in any agreement, for instance, with respect to the financial side, if there's a plea agreement. Now, as you might imagine, both restitution and forfeiture are areas that really are fertile ground for litigation, trying to limit a client's individual exposure, for instance, in a multi-defendant case, or where their family home is maybe at risk of seizure. But it's an area in which it is crucial to have counsel who understands the law on restitution and forfeiture and is prepared to negotiate or challenge the government's attempts to just get money judgments for the total losses or forfeiture of assets that have no tie whatsoever to the offense, maybe that were obtained far earlier than the offense conduct or that shouldn't be considered substitute assets, etc. So we here at Rawson Law Firm have this experience, and we've been successful in limiting client exposure to both restitution and forfeiture, where clients played a narrow or defined role, for instance, in a conspiracy, such that a smaller portion of the overall loss is really attributable to their conduct, and maybe a limited forfeiture as well. That goes after certain proceeds or agreed upon proceeds that aren't close to the total loss, but are a fairer representation of a client's culpability. And, if the government goes unchecked, then there's really a danger of being exposed to much, much higher than is really fair. Now, federal law also provides for civil forfeiture, but that's an entirely different animal that I'll discuss in a separate video because this is enough for you to digest for now. So remember to like and comment, subscribe to our channel, and as always, thanks for watching.